Data fiduciary is who determines the purpose and means of processing digital personal data. This is very important because this is the entity or person who's responsible for the consequences of data breach. So data fiduciary must be means the person who's in control of the data, who determines the purpose and means of processing. Then data processor is one who processes the data. So on behalf of the data fiduciary. So the responsibility of data processor comes on data fiduciary. Processor is on behalf of the processing on behalf of the data fiduciary. Personal data breach is unauthorized processing or accidental disclosure. This is very important. Even accidental disclosure is a breach. Acquisition, sharing, use, alteration, disclosure or loss of digital personal data, compromising confidentiality, integrity or availability thereof. Then there is a new concept which is consent manager. Consent manager will be an entity who will manage the consents on behalf of the data principals, that is the individuals. These will basically be platforms on which a data principal can register himself and then give authorization to the consent manager to manage his consents, withdraw the consents, overlook the consents, and all that is done to be done on behalf of the data principal with the data fiduciary. So all those responsibilities will be taken care by the consent manager. Then these two slides largely I had covered last time, but I think for hospitals, in a hospital's life, these incidents happen again and again. That's why I thought that I shall again take those two slides and brief the audience, because some of the audience might have missed the last session. So in a hospital life cycle, the blurred consents come very often. Those are the consents. Suppose a consent is obtained for treatment, and then later that consent is used for marketing, for marketing certain other products or for cosmetic related services. Then that consent has to be taken again. I mean, the consent can't be blurred. It has to be specific. It has to be for a specific purpose. Then data overreach. Suppose in physiotherapy clinic, it collects mother's maiden name unnecessarily. So that is data overreach. So there is a principle of data minimization, which I will cover in later slides. So this is a breach of that principle. Then unsecured spreadsheets. In a hospital, often we contain data in Excel sheets. Those Excel sheets are stored in our laptops and in our mobiles, and they are often open Excel sheets to which anybody has access, which contains huge personal information relating to patients. So these unsecured spreadsheets they may amount to data breach under the Act. Then the EMR vendor breach. Suppose there is an external EMR server cyber attack, and which the hospital is using from an external vendor. And because of that cyber attack, if personal data is compromised, then the hospital will be held accountable for the breach of the EMR service provider. In WhatsApp group reports, very often there are multiple WhatsApp groups created in a hospital, whereon the consultant keeps posting, the nursing staff keeps posting, the ICU staff keeps posting the updates about a patient. So there are multiple members of on the WhatsApp group who are actually not required to have access to some of the information. If such access is given without the consent of the data principal, then that may also amount to breach of personal data. Then lost laptop. So suddenly, suppose someone's laptop is lost, it contains personal data, personal information, then those kinds of incidents can also amount to breach of privacy. That there are certain measures also I have suggested in these slides, that there has to be encryption, there has to be remote wipe capability, central server storage, incident response SOP. So mitigation measures also have to be implemented accordingly while storing personal data on open devices. New product promotions. Suppose there is an old patient data which is lying in the system, which is used, and the patient is approached by the marketing team for promotion of a new product launched by the hospital. that may also amount to privacy, breach of privacy, because the data which the data principal had given was not for the purpose of promotion of your new product. Website form without consent notice. So we often have registrations and the appointment bookings on websites where the patient shares their personal data, and which consent form collects certain information without purpose notice for what purpose that information will be used. So that consent notice has to pop up, and it has to provide the purposes for which the data will be utilized, so that the user gives a consent and then he proceeds to fill the form. Then Facebook pixel marketing analytics tracking. So there is suppose there is a infertility page or any other specialty page where on a patient comes and fills in data, and then that information is fetched by our website, and that information is on the back end shared with a social media service provider like Facebook or Google or say Instagram or any other, Amazon for that matter. So in that case, it's a breach of privacy because the patient had not shared information for sharing onwards with any other third party. So that those precautions we have to take. We have to design our websites in such a manner that they don't discreetly share the data collected through website to third-party service providers or advertisers. Failure to dispose of data. So there is, suppose we have 10-year-old patient database retained beyond necessity. Suppose law lays down a timeline for retention of certain data, and the data is retained beyond that timeline unnecessarily, then that may also amount to breach of privacy of the individual to whom the data relates. Then there are unsecured scan folders which are stored on various laptops and computers of a hospital team, and anybody has access to those folders without necessity. So those kinds of unauthorized or unnecessary access without access control and security measures being implemented may also amount to uh, breach of privacy of that individual. Then very often a question is asked to whom the act is applicable, whether the act is applicable only to hospitals. The act is applicable to each and every personal data. It is not applicable only to hospitals. It is applicable to any personal data which is collected by anyone. May it be the data fiduciary, may be a company, an individual, a state, a HUF, or any other legal entity who collects and processes personal data for a certain purpose, then this act becomes applicable. So while implementing the compliance measures under this act, there is a four-way mindset which is required, which requires that first of all, compliance is a process. It is not a paperwork. So this is not just a formality to comply with the Digital Personal Data Protection Act, because this is a very uh, innovative act which contains even accidental disclosure as the breach of privacy. It contains huge penalties which range from 50 crore to 250 crore. So huge penalties can be attracted. So it should not be looked at lightly. So it's not just a formality, it's a process which needs to be implemented. There has to be focus on systems, people and vendors together. So what systems we are following, which are the people involved in following those systems at the hospital, and what our vendors are doing, how our vendors are taking care of the personal data shared by the hospital with the vendors. Then create a privacy aware workflows. The workflows in the hospital should have privacy at the center stage, which I will of course deal in my later slides. And we have to build a trust amongst the data principals and not fear that I am sharing this personal data, then it can be shared for any other purpose. So that fear should be eradicated, and an atmosphere of trust has to be built. Then this act and the rules revolve around certain foundational principles of data protection. And these foundational principles are universal principles. They are You can find those principles in GDPR, you can find them in HIPAA, you can find them in the CCPA of California, or any protection act, data protection of any act of any country. These principles are common across the universe. The first principle is lawfulness, fairness, and transparency. So the fiduciary and the processor of the data have to process it for lawful purpose, for fair purpose, and there has to be transparency. So these are the provisions. I will not deal with sections in detail in this webinar, because I believe that this is not a purely legal webinar. It gives an overview of what lies ahead and what is the subject all about. So first principle is to be adhered, just to ensure that the data is processed for a lawful purpose and fairly and with transparency. Second is the purpose limitation. So the data which has to be obtained, the purpose for which the data has to be obtained has to be clear, and the data has to be utilized for that purpose only. There has to be a specific consent in which the purpose and the means and the ways in which the data will be utilized. So that those specific purposes, the ways and the means of processing data have to be notified to the data principal by way of a notice before taking the possession of the data. The notice also has to contain the grievance mechanism, the redressal mechanism, and the right of the data principal to escalate the matters to the data protection board. So purpose limitation is very important principle which has to be covered under the notice which is to be issued and the consents which have to be obtained from the data principal. Then data minimization. So very often it is observed that we collect data which is not limited to the to achieving the purpose for which the data is being shared. Like I gave an example, in a physiotherapy clinic, if mother's maiden name is mentioned in the form unnecessarily, it is not a limited information. You are collecting unnecessary, unlimited information. Suppose the certain information like where the data principal has reside in past, that is not necessary. So those kinds of informations which are not necessary have to be avoided. So that is data minimization. Then accuracy. Very often the data which is shared and then it is processed, and the outputs which is given comes out with inaccurate information. Suppose there is a lab which collects data of an individual who is a female, and in the report it is notified that it is mentioned as a male, then it's not accurate. So that may also amount to breach of principles of privacy. So the data fiduciary processing the personal data has to ensure the completeness, accuracy, and consistency of the data. Storage limitation, which means that the data must be stored only till the period to which till which it is necessary to be stored. After the purpose of processing the data is over, that data has to be removed from the system, and the data principal has to be informed in advance that we are going to remove your data from the system. If you have any other concerns, you can please let us know, and then the data has to be removed from the system. Integrity and confidentiality, which also requires implementation of security measures. So data fiduciary has to implement security safeguards. Then data fiduciary shall send notifications of breach to the data protection board and also to the affected data principal about breach of privacy of that data. So under the rules, data protection, digital personal data protection rules, immediate notification has to go, provisional notification after an incident has happened, and also within 72 hours of breach, there has to be a detailed report to be filed by the data fiduciary to the data protection board as containing as to the what is the nature of breach, then what are the reasons of that breach, and what are the possible mitigation measures which the data fiduciary will implement to mitigate the consequences of the breach. So that is integrity and confidentiality. Then accountability. Each data fiduciary has to appoint a grievance officer, and the name of the grievance officer has to be published on the websites in the privacy policy. Also, there are significant data fiduciaries who collect and process large scale data, and there are certain measures or criteria under section 10 under which data fiduciary can be uh, determined by the data protection board as a significant data fiduciary. I think most of the hospitals which have large scale patient base and multiple branches, they will be designated as a significant data fiduciary. And those significant data fiduciaries are under an obligation to appoint a data protection officer who shall be a qualified legal officer and who will be reporting to the board of directors. So that's a very important obligation under the Data Protection Act and rules. Then significant data fiduciary also need to appoint independent auditors, and they have to conduct periodical audits of data impact assessment and also the compliance which the data fiduciary is carrying out from time to time. So these auditors should be independent. The auditors obviously will be certified by the data protection board to carry out the audits, and those kinds of entities or individuals will have the right to carry out the data compliance and impact assessment audits. Then informed consent, obviously we as hospitals, we must have heard this concept very often, that informed consent, but our informed consent relates to the treatment given to the patient. But here the informed consent means the consent obtained for collection of the personal data, and the consent has to be free, it has to be very specific, it has to be informed, unconditional, unambiguous, with a clear affirmative actions signifying an agreement to the processing of personal data, limited and necessary to specified purpose. So this is how the consent has to be. So the drafting of the consent is very crucial. It has to be done by experts, and such consents shall play a very crucial role in uh, determining whether valid consent was obtained and whether the data was processed for the purpose which is authorized under the consent, and whether it is processed properly pursuant to specific consent. Then these are the principles of privacy by design. There is a concept called privacy by design, which is also followed by GDPR, and which necessarily means that privacy has to be at the center stage. It has to be at the uh, core of the uh, information technology architecture of the data fiduciary. So these principles are very important, and every data fiduciary should know these principles, because what happens is that we outsource our implementation of compliance to a third party agency, and then that outsourced agency implements the compliance mechanisms in their own manner. But if we as the data fiduciary don't know what is meant by privacy by design, then there may be lapses, and at least some team members of our organization should be aware of this principle. So what is the first principle of privacy by design? It has to be proactive and not reactive. It has to be preventive and not remedial. So any law, for that matter, even the Data Protection Act or the data protection rules, they are reactive. Okay, if suppose certain incident happens, then certain penalty flows in. So somebody makes a complaint to the data protection board, and data protection board carries out an inquiry and imposes penalty. This is a reactive response. However, the privacy by design principle requires that the organization has to be proactive. It should anticipate and prevent privacy invasive events before they happen. Organization should take preventive measures rather than reacting after a breach or violation occurs. I will explain in later slides how preventive measures can be implemented. Privacy, second principle is privacy as a default setting. So the setting of the infrastructure, that is in hospitals there is uh, HMIS systems. Okay, so or HIMS systems which collect personal data and the data flows through the system. So that system setting should be privacy setting by default. What do I mean by privacy? Very often the hospitals are concentrated, their systems are concentrated for protecting the information of the hospital. They are concentrated for preventing any cyber attack or any loss of data. But that approach is from the organization's point of view, to protect organization's data. Here, what we are talking about is an approach from the patient point of view or the individual's point of view to whom the data belongs. So the privacy has to be a default setting. Personal data should automatically be protected in our systems. Individuals do not need to take action to secure their privacy. It should be built in by default. That is very important principle of privacy by design. Third principle is privacy embedded into design. It has to be embedded. It should not be an afterthought. It should not be an add-on feature. The process of privacy should flow throughout the system and it should be integrated in the architecture of the system. So whenever you design the system through which the data flows, that system should be designed in such a manner that privacy is an embedded feature in that design. Then there is to be full functionality, which is called positive sum and not zero sum. What do I mean by this is, see, our systems are designed for business efficiency, for innovation, for security. They are designed for the benefit of the organization. These systems are not designed for protecting the privacy. When we are talking about privacy, the systems should have a balance between privacy and all these other aspects of security, innovation, and business efficiency. If either of these two aspects supersede the other, and the net sum of it is zeroing one of them, then it's not a adherence to the principle of privacy by design. Suppose I'm compromising revenue at the cost of privacy. Suppose I'm compromising innovation or security of my system at the cost of privacy, then it's not adherence to this principle. On the contrary, if I'm compromising privacy at the cost of security and business efficiency, then also this principle is not being adhered to. So it has to be fully functional, a positive sum, not a zero or negative sum. Then fifth principle is end-to-end security life cycle protection. So we have to be aware, the information technology team of the hospital, also the compliance team of the hospital has to be aware as to at what point the data enters the system, how the data travels throughout the system, at what points the data touches at various touch points in the system, how it is processed at various touch points, and at what point the data gets out of the system. So this entire life cycle of personal data in our system has to be end-to-end secured. There has to be security measures like encryption, like anonymization, or like pseudo-anonymization. Those kinds of measures, access control, so those kinds of security measures have to be implemented end-to-end, not at a certain point, but from beginning to end. Visibility and transparency. Organizations, that is the sixth principle, organizations must operate in an open and transparent manner, ensuring that stakeholders can verify that privacy safeguards are functioning as promised. So those stakeholders are the data principals. They should have access to their information and they should be sure that the organization is implementing reasonable security safeguards. Then respect for user privacy. That is the seventh and important principle. Systems should prioritize user-centric privacy, offering strong privacy defaults, clear notices, and user-friendly options. So these are largely the principles of privacy by design, which we have to be mindful of while implementing our data privacy compliances. So I was talking about access control and security. Very often it happens that in our systems, many of the team members have access to a certain kind of information. And some of the team members who really do not require to have access also can access the information and see the information or process the information. So we have to implement the data access to authorized staff only. So when it comes to personal data of our patients, the access to patient data should be given with a login and password to a certain staff who is actually required to have access to that data. Then security failures trigger breach notifications. That has to be, the staff has to be educated about it. Avoid unsecured spreadsheets and shared devices. This is very often it happens in hospitals that unsecured spreadsheets are flowing across the organization, and shared devices are also utilized. There are tabs, there are mobile devices which are shared. There are also laptops and desktops which are shared, and multiple people use them. So that has to be uh, uh, prevented. And if at all it is necessary, then it should be with a strict user and password control. Then personal phones and laptops, they increase the risks. So when individuals use their personal phones for processing the patient's personal data, then from that personal phone, the information can go out. There are various applications which nowadays we install in our mobile phones, and those applications discreetly have access in our image gallery, in our other documents folder and the files, and from there data breach can take place. So we have to mindful about that. Data minimization, I spoke about it. Lesser is safer. Collect only the data which is required for treatment or for operations. Avoid sensitive identifiers unless legally required. So identifiers means the data by which the individual is identified. So unless it is necessary, they should be anonymized and pseudo-anonymized. Excess data increases breach risk and liability. So that also should be avoided. We have to minimize the collection of data. Then WhatsApp and digital communications, please avoid sharing reports on personal devices. If at all it is necessary to be shared, then it is to be shared only to a restricted group, which is actually required to have access to that personal data. Use secured hospital channels only. Mask the identifiers of uh, patients wherever possible. Train the staff on safe communication. What are the safe communication practices? Those trainings have to take place. Then websites and platform etiquettes. From our websites, we very often collect a huge personal data. So purpose notice has to be there on all forms on the website. Whenever a patient comes and the patient shares personal data on our websites under certain forms, we have to ensure that data collection point clearly states why the data is being collected and for what purpose it will be utilized. Clear opt-out mechanisms have to be there. Provide easy and accessible ways for patients to opt out of communications. Separate checkboxes for every consent. So never bundle every consent that is for treatment, for service, for marketing, for promotion. They can be in one consent, but under one consent form, there have to be different specific checkboxes for each type of consent, each type of purpose for which the data is being collected. Then review the use of analytics and pixels. Audit all third-party tracking tools on hospital websites and portals. Very often, our websites are on the back end sharing the informations with third-party tracking tools, which has to be audited, and it has to be ensured that such unauthorized and without consent sharing of information with third-party tracking tools should be prevented. Audit and review, we have to conduct audit of all digital touch points, as I said previously. Identify missing or weak consents. Create simple SOPs for the staff. Align HMIS marketing and communication systems. Then hospital focus areas for compliance. What are the focus areas in which the hospitals, should focus? for implementing the DPDP compliance. So patient consents, design SOPs for IPD, OPD, and consultation consents. These consent forms have to be designed by experts. You have to engage expert firms or service providers who are providing information and who have knowledge to design the specific consents to be obtained for each of the purpose. Link the consent records to patient MRNs in HIS and EMR systems. So it may happen that you will have to prove in future that you had actually obtained the consents. Most of the times now the hospitals are operating on digital platforms. Their patients are registering on digital platforms. Their messages are going through WhatsApp and text message communications, in which you can obtain consents in digital forms. However, those consents have to be linked to your system, and it should be linked in such a manner that in future, if it is necessary to prove that I had obtained consent for this purpose, you should be able to prove that you had obtained consent for this specific purpose. Then consent withdrawals mechanism for all types of personal data. Those mechanisms have to be implemented, and the patient should have right to withdraw his consent for a specific purpose. Suppose you have taken consent for 3 purposes and one of the purpose is served. Thereafter, the patient should have an option to withdraw those consents for the purpose which are actually served. Access control and security, which I just discussed, that implement role-based access controls for clinical and admin staff, carry out audit of logs for every access to patient data. So whoever from our system is accessing personal data, there has to be logs maintained of who accessed, when accessed, from which device he accessed from our team. That those logs have to be maintained, and audit of those logs have to be carried out periodically. Implement encryption of stored and in-transit data. So suppose patient data is obviously stored with us. To prevent the breach of privacy, that stored and in-transit data has to be encrypted, and only those people should have access who are actually authorized to have access. Breach response SOP has to be there. So establish a 72-hour breach notification process, because this 72-hour timeline is mentioned under the digital personal data protection rules, that under a breach event, a detailed report has to go to the data protection board within 72 hours, and a immediate breach notification has to go as early as possible within a reasonable time to the data protection board as well as to the affected data principal. Then create and implement patient notification templates and procedures. For breach notification, there have to be templates. Those have to go to the patients in case of breach. IT department to have incident response team with defined roles. So the IT team members must be aware that if a data breach is committed, if an incident is notified, then how it is to be responded. Who will play what role in responding? Who will send the notification? Who will notify the data protection board? What will be the content of the notification? All that training has to be given to the IT team. Train the staff on breach response SOP. So on this SOP, the staff has to be trained. Then very important is last box, which is the vendor and partner governance. You have to implement robust data processing agreements with vendors. When you enter into an agreement with the vendor and which vendor is required to process the personal data of your patients, you have to have robust clauses in the agreement which makes the vendor liable and indemnify you from any consequence which may arise from the vendor's breach, because under the act, the fiduciary is responsible to the principal. So patient can hold responsible the hospital, not the vendor. So the hospital has to have very strong clauses in the agreements with the vendors, whereby the vendor can be held responsible to the hospital. Implement vendor risk assessment framework. You have to carry out a review of what are the risks which you have with your vendors, what kind of systems the vendor is using, what kind of softwares and what kinds of the processing mechanisms the vendor has, and whether they are compliant with the DPDP processes, and whether you are at risk by sharing the information with the vendor. Incorporate third-party audit rights in the vendor agreements, whereby you can uh, call upon the vendor to, to submit to you a third-party audit report of his systems and compliances, monitoring. So those kinds of clauses have to be there, which entitle you to carry out, uh, uh, make the vendor responsible to carry out third-party audits at his cost, and also compliance monitoring of the vendor. You should have the enabling clauses to monitor the compliance of the vendor for DPDP. Ensure contractual obligations for data processors. Then this is a high level path. I'm sure in one session it can't be ensured that everybody will be compliant, but this is largely the path which the hospital should follow. First is to create awareness, educate the medical staff, the interns, the admin, and all other staff on DPDP Act fundamentals, which I discussed in previous slides, and the legal definitions. So the staff has to be aware that what are the legal definitions, what are the consequences, what are the processes, and what are the fundamentals of this act. That is what our team should be aware of. So that awareness sessions have to be created with the help of experts periodically, not only once but periodically, because this is a new law, and as everyone knows that every new law undergoes various changes and upgrades and updations. So the team who is updated about the knowledge has to carry out the awareness sessions with our teams. Then data mapping. Second step after awareness in a hospital is we have to inventorize all personal health information. Identify where the medical records are stored. Not only medical records, but where the personal information is stored, who has access to that personal information, and how they flow between the departments within the organization. Suppose I represent legal department. Certain information comes to my department. From my department, it goes to a regulatory authority from whom I am required to obtain license. Or suppose my information goes to the supply chain department. As a legal person, I share information with supply chain for ensuring that the contract is signed. Then these kinds of data flows have to be identified within the organization. So where the data is stored, who has access, and how they flow between the departments. So that is called data mapping. So that kind of mapping has to be carried out of your own individual hospital systems. Then data impact assessments. Perform data protection impact assessments before implementing new technologies like AI diagnostics or remote monitoring. So we very often take these services of systems which provide us AI diagnostics or remote monitoring or any other, for that matter, SaaS services or any other cloud services, where we keep sharing our information. And what impact those sharing of informations with third parties will have on us, that impact assessment has to be carried out. So that's the third step. Then gap assessment. Conduct a risk assessment of the hospital information management system, that is HIMS, which nowadays every hospital has this HIMS, and I'm sure NABH also has this digital transformation drive and initiative. In fact, this webinar is also part of that digital transformation initiative. So every hospital is going digital. So we will have to carry out gap assessment of what are the risks from privacy point of view, not from security only point of view. We have to be mindful that security is a subset of privacy. All these days we had been thinking that firewalls and securities and protecting the information and confidentiality of the organization's information is at paramount importance. It is important, but it is a subset of privacy now. Privacy presupposes security. Security doesn't presuppose privacy. That's the difference between these two. So we have to carry out gap assessment of our own HIMS systems and find where are the privacy lacunas and gaps. Privacy policies create a patient-facing privacy policy notices and clear consent templates for the hospital's patients portals. Privacy policy plays a very important role. It gives what is the hospital's approach towards the information of individuals, for what purpose hospital uses that information, how it looks at the information, how it processes, who's the grievance officer, how the grievance officer can be reached, what are his contact details. Those informations, those particulars have to be contained in the privacy policies. And consent templates should also be very specific. As I earlier discussed, the ingredients of consent. Those ingredients have to be followed in a consent. Patient rights desk, it is very much advisable that there has to be a dedicated desk. By desk, I don't mean a physical desk. It may be a virtual desk whereon the patient can come, the patient can reach out to the hospital, he can share his grievances, and you can revert to the patient with your mitigation measures. So set up a patient right desk or portal to manage requests for data correction, data access, or withdrawal of consent. This is largely the journey which the hospital should follow to implement the DPDP Act compliance. I think this is the last slide. So these are 3 I's which I have formulated as a data protection professional, that identify, implement, and inculcate. So we have to identify data and the exposure. What data we have? Data means personal data, individuals' data. What individuals' personal data we have? That has to be identified, where it is lying, how it is flowing, who all are using it, and how it is being disposed of, and how we are exposed to this consequences of this act. That identification is a key for compliance. So first identify, then implement whatever I told in the previous slides. Implementation should be embedded in consents, notices, and vendor controls. So implement the compliance in the manner which I told. This is very high level compliance particulars which I just told. The actual implementation will go very detailed to each and every department, to each and every team member who deals with personal data. That's how the actual implementation will go. Each and every type of data, each and every consent, and each and every template has to be seen very carefully. So implementation plays a vital role. And then inculcate. By inculcating, I mean educating the team. Inculcate the culture of privacy, breach response, training, and audits. This is not a one-time job. This is a recurrent and frequently again and again occurring job. So this job has to be inculcated. This culture of privacy has to be inculcated across the organization, and culture of breach response, culture of training and audits has to be inculcated within the teams. So this is what I intended to cover in this presentation. And I think this was helpful to all the team members. But be mindful that this is not only applicable to hospitals and healthcare. This act is applicable to everyone who's engaged in processing personal data. So thank you so much. Thank you.
Thank you so much, sir. Uh, I think we've got a lot of questions, uh, hands raised. I'll start with Dr. No, Mr. J. Imran Khan. Yeah, yeah. You can unmute yourself, Mr. Imran Khan, and ask your question. Mr. Imran Khan, are you there? All right, I'll move to the next participant, Mr. Manjunath. No, Miss Manjunath. Do you have a question? Mr. Manjunath, do you have a question? Yeah, I see their hands were raised for a long time, so probably the answers they got their questions answered. We'll move on to the next one in line, Mr. Pramod David Jacob.
Yeah, hello, can you hear me?
Yes,
Yeah.
I can hear you.
Okay. Dr. Amit, very specific use case because this is where we're having a little challenges. The use cases, firstly, we are talking of the hospital signing the contract with the vendor with that indemnity clause. If you can give a brief example of what that indemnity clause should state, that would be helpful. And then let's take a case of where a breach has happened in the case of where the in an area which is under the vendor's responsibility. Now let's take what happens starting with the patient taking some sort of action towards it, and then how does the hospital manage to get indemnified for or what get indemnity for it? Can we because this
Yeah.
is needed to assure our clients.
Yeah. So the indemnity clause necessarily means that whatever consequences the hospital faces due to the action or omission on the part of the vendor, those uh, consequences which hospital faces because of the lack of action or because of any action on the part of the vendor, those consequences should be taken up by the vendor, and the vendor has to pay that amount or say implement whatever the patient is asking to the hospital. So those kinds of clauses have to be there. So vendor, first of all, you have to have in indemnity clauses, you have to have first of all that there has to be a representation also from the vendor that he is compliant with the processes and the requirements of this act. Secondly, if any breach occurs on the part of the vendor, and because of that breach, if hospital faces any consequences, the vendor has to pay to you. Now, for recovering that amount, obviously one has to go to court. To avoid that and court takes time. So to avoid that, you should have clauses which entitle you to deduct the amounts from the payables to the vendor, also withhold his payments. So those kinds of enabling clauses which entitle the hospital to immediately address the consequences, those proactive clauses have to be implemented in an indemnity.
Okay, thank you. That helps a lot.
Thank you so much. We'll move on to the next one, Dr. Rupa Ashri, if I'm pronouncing it right.
Thank you so much. First of all, I would like to congratulate Dr. Amit Kumar for his wonderful talk, and it was really very nice and very much informative. Really, it was a enormous information. My question is, please tell us about audit touch points in IT. A little more in depth, I would like to know. Second question mine is it is related to information about vendor risk assessment framework. You did mention to me about this. So is there any specific standards or a template or something related to vendor risk assessment framework while we are taking it from the hospital sector? Now, another question is I wanted to know about is this gap assessment in HMIS. I come from audit perspective, so I would like to have some practical ideas from you. What challenges, what limitations have you been able to face during your experiences? Please do give us some more information. Now, the last question is I'm asking about your impact assessment you did mention to me about this impact assessment. Is there any framework or standards used for impact assessment, or is there any literature that I can refer to about this? Please share your personal experience on these things. That would give us more insights. Thank you so much.
Yeah, thank you so much, and for the kind words and so many questions. I think I forgot all some of them, but as I recollect, I think your first was the audit touch points. So the audit touch points means that you have see every organization has different style of handling personal data. So your organization's peculiar data flow has to be identified. How your organization collects personal data, after collection of personal data, with all which all are the teams within your organization to with whom the personal data is shared after collection. Suppose a patient comes and registers at the OPD desk, and from OPD desk, the individual who's sitting there, the hospital professional who's sitting there, collects the personal data like Aadhaar number or PAN number or a bank account number, and then shares with the accounts team, or it shares with ER. So each hospital has a different system. So you have to identify with whom all the information after it comes in is being shared, what all are the stakeholders who are dealing with that information, and what are the processes which they are carrying out with that information. These are by audit touch points, I mean that where all the information is flowing within your organization, that you have to identify. And that identification can be done by an expert service provider by frequent interactions with all your team members only. So your team members only can enlighten the service provider about it. So that is what I meant by audit touch points. Second, you said, are there any frameworks? Obviously, there are frameworks, but not under the DPDP Act. There are service providers, there are multiple service providers across India who have now started delivering services under the DPDP Act compliance. They can give you frameworks under the GDPR and other foreign regulations, which the IT companies in India follow, because GDPR also has an extraterritorial jurisdiction beyond EU. So those frameworks must be there with the IT companies, and there are online available GDPR frameworks are also available. Even the binding corporate rules, the general contractual clauses, all those are there in place under GDPR and HIPAA and CCPA, that is the California Consumer Protection Act. So many compliance frameworks are there, but for your organization, you'll have to design one, because your organization is unique. Every organization is unique and it has unique processes. So those SOPs you'll have to design specific to your organization. So frameworks are there. As far as my practical experiences are concerned, I'm sorry I can't share, because I am representing one organization and I can't share beyond a certain time, beyond a certain limit. But these are the largely areas that you have to carry out the assessments of how the data is flowing, with whom all it is flowing, and where it is getting out. Third was your impact assessment. So breach impact assessment is there, that privacy, if it is breached, then in what nature and to what magnitude it is going to impact your organization. That assessment has to be there. And whether your systems are compliant, that assessment has to be carried out from privacy point of view by an expert who knows. I know various privacy fundamental service providers, and Dr. Priyanka can share my number to this chat with all the attendees. They can reach out to me anytime to know further on this, and I can also be happy. I'll be happy to give you information without any returns, because I'm full-time working with an organization and I'm not going to give any services, paid services, to anyone. So anybody can ask me any question if at all. Dr. Priyanka, you can do that with the attendees.
Absolutely, sir. We'll share your number. And apart from that one, would just like to add from NABH side, we're as this laws just come out recently, we're working on upgrading all our standards, whether it's related to softwares, HICMR or CMS, or the digital health standards for hospitals as well.
Hello,
So you'll
hello.
yeah.
Sorry.
Could you please wait for
Yes.
your turn? Hmm.
Can I ask a question?
Sure. Could you please wait for your turn? We'll come to
Okay,
you.
okay.
First of all, thank you so much, Dr. Amit, for your focused and genuinely, I would like to say my gratitude and really appreciate you for your answering every question of it. Thanks a lot.
Thank you.
So you should so to continue what I was saying, I think you can see the updates on DHS standards. I think that could be one of the roadmaps that for the hospital on what else to accomplish to make sure your hospital is compliant with DPDP. Right. We'll move on again to the question and answers. Mr. Rahul, you can go next.
Hello.
Yes.
Sir,
Yeah,
thank
I
you
was.
for. Yeah, I think Mr. Pranay can go first, then I'll ask.
Thank you.
Yes. Okay. Thanks. Sorry to interrupt. I was asking how will the patient access to the portal for how will the patient access a portal to get to their personal data if they want to correct it? How will they correct their personal data? What is the process for small healthcare organizations?
Yeah, so you will have to consult your IT team, or if you don't have a in-house IT team, then you'll have to engage one, and in consultation with the data privacy service providers
Yeah.
under the relating to this act, your IT systems have to be designed in such a manner that the patient is given with a certain login or password, or the patient can be provided with a certain credentials through which he can have access to his own personal information, and he should be provided with the information whether the purpose for which the information is shared is accomplished, and thereafter he should be able to withdraw the consent and to request you to delete the personal data which you store. But the process has to be designed by the IT team.
Sir, one more question is that will the patient be able to see only his data? Because if you are giving a password and ID, will that be access to only that patient's data only, or for the other data also?
Not at all other data. How can a patient access other data? His access should be limited to only his personal data.
His personal data. Okay. Okay. Thank you, sir. Thank you very much.
Yeah. Thank you.
Right. Thank you. So we'll move on to Delhi Mail. I don't know his or her name. Please, someone logged in with Delhi Mail.
Yeah,
You
hi.
can go next.
Yeah, hi.
Yes.
May I ask my question, please?
Yes, please go ahead.
Yes.
Yeah. Thank you, Dr. Amit, for this insightful session. I am from a company called as Datamin Computers, and we basically are HMIS vendors. So, can you please specify us how HMIS would deal with this DPDP policy? What are the compliances that an HMIS should follow, and what certifications does an HMIS need for this DPDP Act?
Yeah. So the act requires that certain ISO certifications are mentioned in the act, which is, I think, ISO 27001. You must be having one. Okay. If not, then I advise that you should have one. Secondly,
Sir, which certification, sir?
ISO 27001.
Okay.
Okay. And secondly, you are not directly facing the patients. It is the hospital who's buying the HMI service from you, and the patients are sharing the information with the hospital. So you per se are not answerable to the patients. The hospital is answerable, but you being the data processor who's processing the data on behalf of the data fiduciary, that is the hospital, you are responsible to the hospital. And if a patient raises certain concern about your HMIS system and lacunas in your system or lapses in your system with the hospital, then the hospital will raise those concerns with you, and you will be responsible to reimburse those consequences to the hospital.
So what can be done for being an HMIS vendor? What can be done from an HMIS perspective that ensures data policy accept certification like 27001, as we already do have that certification with us. What else we can do to protect that patient's data and to make ensure the hospital the data protection is completely secure?
You must be aware what is the flow of data in your HMIS system, how the
Right.
data gets entered in your system, how it is flown, who all are the stakeholders who have access to the personal data. So those access control mechanisms have to be implemented. If required, encryption mechanisms have to be implemented. Who all are the stakeholders with whom the data is shared from time to time through your system, and whether it is compromisable, whether the system is such that the data can be accessed by a external party, or a person who doesn't have access to your system. So those measures to control the access and to ensure that the privacy of the data is not compromised, you will have to carry out an assessment of your own system with the help of definitely the experts in this field who will carry out the flows within your HMI system and guide you further that this is where there is a gap, this is where there is a vulnerability, this is where the data can be seen or downloaded from unsecured computer system. That's how you'll have to look at your system from the privacy point of view.
Right, sir. Right. Thank you, sir. Just one more question. Do we need to do an HMIS vendor do need to apply for a DPDP Act certification, something like this? Is that available?
Currently, it's not there. Once the data protection board gets constituted, the data protection board will pass notifications as to who all are required to get certified.
Okay.
Okay. Thank you. Thank you, sir. Thanks for the information, sir.
Thank you.
Thank you.
Avinash, sir, would you like to add to this one? If you're there.
Yes,
Right.
just wanted to kind of add there. See the NABH DHS certification, right, for HIS and EMR. You know, it already kind of takes in a lot of the requirements of DPDP, but very specifically the next edition, which is going to come out in September. There, we are actually working on a OE by OE, I mean, objective element by objective element, impact of DPDP on each of the OE. So a revised interpretation is what you can expect. That is one. And in case there are some new objective elements that needs to be added in the standards to comply with DPDP from a software perspective, HICMR perspective, that would be done as well. So you can expect that the next edition that comes out in September would actually be taking care of that. And Dr. Amit obviously is part of a SME committee, which is going to validate that when it comes out before it goes for a public domain.
Thank you.
Thank you.
Thank you, sir.
And thank you so much for adding in that, sir. Moving on to the next question by Mr. Prashant Singh.
First of all, thank you so much, Dr. Amit, for a wonderful and insightful session. And you made it very, very simple from the complexity. It's a very, very complex act, but you present it in a very, very simpler way. My
Thank you.
question is pertaining to the DPO. So from the DPO perspective, first of all, is it a IT management or legal role? That is point number one. Can a CISO take the DPO functionality or role?
Very good
And
question.
and the third part of the same function is basically, So you said the DPO will directly report to the board. So,
Yes.
so that is, but what will be the reporting structure? What might be the reporting structure in terms of the governance and the administration? So that
Yeah.
is one, aspect from the DPO perspective. The second one is related to, because healthcare is having various sectoral regulations. So and DPDPA is talking about the right for the erasure of the data also by the data principals. So in that case, actually, who will supersede, the DPDPA or the sectoral regulations? So these are the two parts of the questions. Yeah.
Yeah. So first about DPO. So DPO and CISO are two different roles, absolutely different. And this is a very good question. I did not expect that this question will come, but very good question, and it will help many organizations. See, CISO's role is to protect the organization from external compromises of organization's data. That's what the CISO does. The CISO is the Chief Information Security Officer. Okay. He protects the information of the organization. Okay. DPO, whereas, is the Data Protection Officer. And what do you mean by data? Data means, under this act, data means personal data. And personal data means the data of the individuals to whom it belongs. So DPO is the protector of the information of the individuals, whereas CISO is the protector of the information of the organization. He has on his mind, he always has the priority of the organizations. Whereas DPO should have priority towards the patients and towards the individuals to whom the information belongs. So my view, and it's a very clear view, that CISO should not wear the hat of DPO. That's very clear from my point of view. Because CISO will always have organization on his mind. Okay. Secondly, whether he should be qualified as an IT professional or a legal professional or some other professional, he should be a qualified lawyer. Okay. Because this is a law, and the consents and the mechanisms under the law, the requirements of a consent, the requirements of a notice, these languages and the legal jargons can be demystified only by a lawyer. So I recommend that he should be a lawyer. Thirdly, he has to report to the board. The act contains provisions that he has to report to the board. Okay. And there was one more point which was coming to my mind. Anyways, I missed it, but if at all I have missed anything from your question, you can ask. But the DPO, what I was telling is, appointment of DPO is not mandatory for each and every data fiduciary. It is not mandatory. Appointment of grievance officer is mandatory for each and every data fiduciary. Appointment of DPO is mandatory only in case of significant data fiduciary.
Yeah.
Okay. Yeah.
No, so one more part of the question was, in the organizational hierarchy, will it be, of course, from the DPDP point of view, he'll be reporting to the board, but from the administrative point of view, will he be part of legal or management or IT or what?
So he can be part of legal, management, IT, whatever,
Okay,
but he has to report to the board.
fine. Thank you so much.
Most welcome.
Ma'am, I missed my chance last time. Can I ask the question?
Sure, please go ahead.
Thank you, sir, for the very good presentation. It was very informative. I just have a question from the quality, implementers point of view, that, in hospitals we have a policy for record retention, no, retention of medical records, where we are supposed to follow the government guidelines, and as per that we discard the data when it is beyond a certain period. And there is a circular issued by no Ministry of Health and Family Welfare, that no all the records needs to be converted into digital format before discarding. Now, is
Yes.
there any clause in DPDP Act which defines that period also, that how long we need to store keep the digital records, and what is the method of discarding it? Is there any legal process which we need to follow, which we do in case of no physical records, like we give a newspaper notification 45 days prior, or is so what is the method of discarding, and what is the time frame, so that accordingly we can frame the hospital's policy?
Yeah.
So thank you,
So,
sir.
yeah. So DPDP Act has certain provisions which say that any other law which requires retention of information for a certain period of time, that law is exempted. So you can retain the data under Ministry of Health guidelines for whatever timelines. Like I believe that for OPD it is 1 year and for IPD it is 3 years, and for medical legal cases where there are court cases going on, it is forever it has to be retained. So that is unaffected by the Data Protection Act. It exempts for legal purpose whatever is required has to be retained, and if in any other law requires retention for a longer period, then it has to be retained. For erasure of the information, for deletion of the information, you will have to notify the data principal first that we are going to delete your information. And if the data principal does not revert with a response that please don't retain, please maintain, then you can go ahead and retain with a reasonable notice of 1 month. After that notice, you can delete the information. So that's how it is to be carried out. And how it is to be deleted, it has to be removed from all your systems and processes. You should not have any trace of that information, so that tomorrow you should not have any allegations that you notified that you are deleting, but you retained.
But sir, the circular says, which is given by Ministry of Health and Family Welfare, says that digital records needs to be stored for, I think, indefinite time frame. So because it can be utilized by government for any epidemiological or research purposes. So do we need to keep it for a lifetime? Or?
I don't think there is any circular which requires indefinite retention of all patient data. No.
Okay, so
no.
Fine, sir. Then
I have gone through those guidelines. No.
Okay, sir. Thank you. I'll just again go through.
Yeah.
Thank you.
Mr. Avijit Das, you can go next.
Hi, good afternoon.
Yes, you're audible.
As I joined very lately, I just have a few questions I would like to ask you. Amit, I think you have mentioned about very good points.
Can you be a little louder? I can't hear you. Sorry.
Is it audible now?
It's better, but not very well. Not very good. It's better.
Okay, I just wanted to have some clarity. Like as you said, under condition of the for undefined times for other interventions. But yes, but if any genetic data, even if, for example, if someone open a hospital, it doesn't mean we foreigners will not come to the hospital.
Sorry, I can't understand. Can you understand, Dr. Priyanka? I don't understand.
No, Mr. Das, could you type your question? Yeah. Could you type your question and we'll take it up from the chat? I'll move on to the next one since we are very. Yeah.
Is it
much better, much better. Go ahead now. Yes, it is. Please go ahead.
Is it audible now?
Yeah.
Yes, please go ahead. Mr. Das, can
just I wanted to understand, as Amit rightly said, like
yeah, please go ahead.
Data should not be retained for indefinite time. But for example, if anyone open a hospital definitely every patient will come as Indians or outside anyone. But in that case, if someone do genetic modifications or any genetic disorder treatments, which will be a medical record and which will be used might be for clonings. So in that cases, whether you said about data deletion, is it permissible in that cases? And would like to also ask for auditor point of view. For example, ISO you said about, and for ISO perspective, if someone audit by 27001 or maybe 27017 or 018, and which will also include for certifications like laboratory, every billing counters, every patient data will be recorded in laboratory, pharmacy, billing, radiologies, which is as a internal access. So in that cases, the major responsibility will be for the DPOs or it will be as a CISOs. So which will be a most authorized person, so that if patient asks through RTI, who will be responsible to respond to this one?
Okay. So there are two questions. One is genetic data, whether it is to be retained indefinitely and if it is required in future. See, you are collecting data from the data principle. You know for
Yes.
what purpose it is being collected.
Yes.
So it is better and advisable that you obtain specific consent that this data, the nature of the data is such that it will have to be retained for so and so period. So you obtain specific consent from the patient, no, from whom you are collecting the data. If
But
consent is
in that cases, government already integrating the health ID cards, numbers and all with health authority. So in that cases, if someone claim to government to understand where data has been used, so in that cases, whether CSO or DPO can act or can give a response.
I was coming to that. That was
Okay.
your second part of question.
Yes.
So your first was the data retention period.
Yeah.
So data retention period can be secured under the consent itself, that you can obtain a consent to retain a data for a certain longer timeline, whichever you want. Okay, that is one. Second, whether DPO should respond or whether CISO should respond or whether should a grievance officer should respond, that depends on whether you are a significant data fiduciary or you are just a data fiduciary. If you are a normal data fiduciary, you have to have a grievance officer. A grievance officer can be anyone. It can be even the CISO. My advice is CISO should not get into privacy. Okay. You should have a different officer who deals with the privacy issues. So grievance officer can be anyone. If you are a significant data fiduciary, there are criteria of significant data fiduciaries under section 10 of the DPDP Act. If you are fulfilling those criteria, and let me not get into all those criteria, then the Data Protection Board designates you as a significant data fiduciary. In that case, only the DPO has to deal with the privacy issues. But if you are a normal data fiduciary, a grievance officer or any other officer who is designated as a grievance officer can respond.
So in that cases, organization sometimes may face heavy financial penalty and violations if this has been occurred. For example, if data is not produced, or it might be variation with DPDP acts. So is there any direct provisions where patient can get access through fast track legal access? Because sometimes if it is not resolved, so it may go beyond DP or CISO levels.
No, the first the patient has to raise the concern with your grievance officer. Okay, so the grievance officer has to revert to the patient within a reasonable timeline, and the issues or the concerns of the patients have to be resolved. If he is not satisfied with the grievance officer, he can escalate it to the Data Protection Board of India. The Data Protection Board of India also does not impose penalties at once. They carry out the assessment of what breach has been committed. And even the penalties which are imposed, they are the higher limits. So they won't jump to the higher limit altogether. Even the amounts which are recovered are not paid to the patient. Those amounts are deposited in the Consolidated Fund of India. They don't go to the patients. So it's not that immediately it will be, you will be penalized or something like that. You will be given an opportunity of being heard. What is the magnitude of loss which is caused to the patient? What is the mitigation measures which you tried to implement? What are the systems which were responsible for this data breach? All those aspects will be looked into by the Data Protection Board of India.
So in that cases, insurance company also will be involved. And if some country, because other foreign countries have a medical coding systems which is directly linked with insurance team for coding. So the insurance persons or insurance corporations also will be involving in these investigations.
Now listen, see, the Act makes the data fiduciary responsible. Who's a data fiduciary? Data fiduciary is the entity or person who determines the purpose and means of processing data. If the hospital is the entity who is determining the purpose and means, hospital is data fiduciary. If insurance company is determining the data purpose and means of processing data, then insurance company is responsible. So whoever is data fiduciary becomes responsible.
Okay. And my last question is, for example, if patients opted not to give a information, so in that cases, hospital deny to treatments? Or like
that's not a privacy point of view question. That's a different question altogether. I think
yeah, but
this is
no,
not the
for
forum to ask.
example,
See,
for example,
denial of treatment is something let me not comment on that. That's a different question altogether. Let's not get into something other than subject matter of this session.
absolutely. And
Right.
yes, yes, thank you.
Thank you.
Thank you. Dr. Rupashri, if you may, please wait. We'll
Yeah.
have one question from Ms. Beena, and then we can come back to you. Would that be okay?
Dr. Priyanka, I have
Yeah.
a hard stop at 4:45 maybe. So 10
All
minutes
right.
more.
All right, sure. We'll try to cover up in that. Ms.
Yeah.
Beena, please go ahead.
Hello. Yeah. Hello, Dr. Amit. So, Dr. Amit, I would want the guidance regarding, does the DPDP Act says that while registering a patient, if the patient does not know his actual date of birth, and if he says that he is, let's say, 60 years old, and we enters the age as 60, should the date of birth be auto calculated based on age, or should it not get auto calculated based on age?
See, first of all, Data Protection Act doesn't say anything about it. It's not a act applicable only to hospitals. Okay. This is a general act applicable to all personal information. This is applicable to Facebook, to Google, to WhatsApp, to Amazon, to Flipkart, to Insta. Everyone, this is applicable. Okay. So if the patient doesn't give you correct information, you should maintain proof that this information is submitted by the patient. So if he
Okay.
submits a wrong information, obviously he is responsible for submission of wrong information.
So basically, here the data has been entered by the facility person.
Okay.
So yeah, so if he says that he is 60 years old, might be because the patient is does not remember his exact date of birth. So currently we are calculating the date of birth, but we have received the request from one of our client that the DOB should not be auto calculated; it should remain blank, and age should only be visible in that case.
See, you should have a specific date of birth. Why your system is having only 60 years or something like that, I can't comment on that. Okay. So that system should be updated, and it's not a question about privacy. It's a question about your systems.
Yeah.
Sir, we have the date of birth field as well, independent date of birth field, but we have both the fields basically
I'm
to
sorry.
add. Yeah, yeah, Doctor,
Yeah,
please.
I think I'd like to interrupt at this point of time. I think the question is not pertaining to DPDP. We'll move on to the next
No
question
problem. Yeah,
because
thank
yeah,
you.
thank you. Dr. Rupashri, I see your question. Is that the same question in the chat box?
May I please just give me a moment? I have three questions to ask. My
Ma'am,
first question is, sorry, give me
sorry,
this time.
yeah, I'm sorry, Dr. Rupashri. I think we've already given chance. Let Miss
No,
Archana
I
ask,
need
and then we'll
to.
come back.
Sorry, I need to speak because you need to give me this opportunity. I want to know about this. I am from international background, so I want to know whether this DPDP Act works for international hospitals and international university. This is my first question. Second thing is related to radiology, ultrasound, CT, and MRI. What is the imaging policy or the retention and the process of if at all it gets hacked? Because I myself have gone through these documents when it was hacked and I was on duty. The second thing is, third question is related to death of the patient. What is the digital records of the patient in case of a suicide case or something? So is there any pertinent specific clause? These are the three questions which are very important for me. Please respond. Thank you.
Yeah. So first question is whether it is applicable to international universities and international hospitals. The act is applicable to data processed anywhere in the world, even outside India, if the data relates to, to the individuals who are within the territory of India. So data has to be of the persons within the territory of India. It is not material where it is being processed. If you are sending your data to international universities, international hospitals, and they are processing in US, UK, EU, wherever, the act is applicable because the data relates to persons within the territory of India. That is answer number one. Second, hacking of your systems. See, there is a compromise of security measures. Hacking means security measures were not adequate and the system was compromised. It is a subset. As I already said, security is a subset of privacy because privacy principles require that the data fiduciary is accountable for security of the information. So you have to be secured and your system should be updated and abreast to protect the information from any hacking or such compromise incidents. That is second answer. I forgot your third question. I'm so sorry.
Regarding the digital CT, MRI, and thing, is there any specific clause?
Death, you said death. Yeah. So see, death and all those legal cases related data, like there is an accident case or there is some other case for which the data is required in a legal proceeding. The Act exempts such information from retention period. Informations which are required in legal proceedings, those can be retained for whatever period they are required to be retained. So that is exempt.
Thank you so much. Thanks a lot.
Thank you. We'll move on to the last question here from Ms. Archana.
Yeah, hello, sir. Hello, Dr. Amit. Very delighted to see answering all the questions. Thank you so much for the very useful and informative session. I want to I have only one question here. You mentioned 10 criteria for SDF. So I want to know whether our organization belong to an SDF or who are all the officials needed. We have to appoint who are all the officials. Like
significant data fiduciary has certain criteria. You check section 10 of the Digital Personal Data Protection Act. It contains 6-7 criteria under which the Data Protection Board of India will determine whether you are significant data fiduciary or not. It's not you or me to decide whether you are significant data fiduciary. If you meet those criteria, you are a significant data fiduciary. If you are a significant data fiduciary, you are casted with certain elevated obligations like appointment of a DPO, like carry on audit from a third-party auditor, like data impact assessment frequently. So those are the additional responsibilities.
Yeah, thank you so much, Doctor.
Thank you.
Right. I think that's all the questions we had today. And thank you so much for your patience. And thank you, everyone, for being such a great audience. I'd like to thank Dr. Amit, sir, for such a wonderful session, insightful session, which was really enriching. I'm sure everyone found it really productive today. We covered all the practical perspectives on regulatory framework, data protection in healthcare, and was extremely relevant and thought-provoking for all of us. I thank you once again for joining in, sir. Thank you so much. We look forward to many such sessions in the near future. Thank you so much.
Thank you. My pleasure. Thank you so much.
Thank you.
Can we contact Dr. Amit?
I've shared his email address and phone number on the chat box.
Can we contact using email or phone number for? What is the timings for the same? Like when can I contact him?
You can send him an email. He'll respond to you as per his availability.
Yeah. Thank you so much,
Thank
Doctor.
you.
Yeah. Thank you.